Hi, Jason Rosenblum here, and in this IP Basics video, we're going to talk about trademarks and specifically international trademarks, protecting your brand internationally. So, a US trademark only protects you in the US. A US trademark also does not mean that you're clear for use in other countries. So, if you're selling in the US, manufacturing in the US, and thinking of selling in Mexico, Canada, you should conduct a search before you file in those before you start using it in those countries because you may infringe on someone else's rights. Another thing to note is that there is no one international trademark. You must file in each separate country that you seek protection. And I'll discuss later on in this video that there are two ways to file, but ultimately you are filing in each country that you seek protection in. There is something called an international trademark that you do get through one of the filing mechanisms, but it does not mean that you have protection in those countries. So I don't even like saying the word international registration because of it gets confusing because it really has no weight in terms of having actual protection. It's just one step in the process. And the two different ways to file are Madrid Protocol or via a direct filing. And when I say direct filing, I mean that we're filing directly with an attorney in that country. So Madrid Protocol is basically just a contract and agreement between most countries. I don't believe every single country is a signatory to it, but about 200 or so are, just or very close to there, 190 something. It's generally simpler and lower cost at the beginning, and potentially if everything goes through smoothly, it could be lower cost. And the main reason why it is because it allows a U.S. attorney to file on behalf of their U.S.-based client through the USPTO into many foreign countries that are all part of the Madrid Protocol. Essentially, it goes through there. They certify that all the details are correct because it must be based off of an already existing US either application or registration. And they certify that the details are the same and correct, and that's when the international registration issues, but that does not mean that it goes through to protect you internationally. It then goes on to each individual country that you elected to file in to seek protection there. And something to note about countries is that the EU does have one place to file. So you can file for an EU trademark that covers all of the EU. The UK is no longer part of that, so that requires a separate filing. But for at least for trademarks, the EU is one of the few places where you can get some wide coverage through one filing. Some of the downsides to filing through Madrid Protocol is that it depends on your US registration. And what that means is if you file an application based off an application and that application never matures into a registration in the US, which can happen for many reasons, it basically opens up your Madrid filings to attack based on that. And essentially what you need to do then is really turn that Madrid filing into a separate national filing, which just adds on a lot of extra fees and extra work. The other downside is that you can't expand goods that other foreign countries might allow. The US requires a very specific description of your goods or services, whereas many foreign countries allow you to be much broader, as well as a lot of foreign countries don't even require use in that country, unlike the US. And then also, I've heard, I haven't seen it yet, but I believe China and some other countries do not provide the same protection to an application that comes through via Madrid Protocol as they would if it was directly filed into that country. So direct filing, the downside, the one main downside is that it has a bit of a higher cost initially, because what we have to do is contact a local attorney in that country and have them prepare and file. So, you have our firm and a local attorney working on it, and you pay for each application separately. So if you're filing in a bunch of countries, then there's also usually additional bank fees that add on to that because you're paying wire fees for each one of those. But there's a lot of pros, such as you have that local expert and experience there to review before you file. You could potentially have them conduct a search to make sure that there's not going to be any issues, as well as if they're, they can avoid some of the potential issues down the road and help that application go through smoother. Another pro to filing direct is that you can expand on your goods and services. As I mentioned before, with the US requires a very specific um, description, and it's usually much narrower than what they'll allow in many other foreign countries, as well as the US requires use. So you can file your trademark for, to protect a lot broader class of goods or services that you might not even be using it on yet, to keep potential infringers away. So something to really know about, and if you work with our firm, you'll know that we send out notifications about this, but there's something called a priority right. And what that is essentially it's another treaty that all of the governments have signed on to that says if you file in your home country, you have 6 months to file in a foreign country, and they will treat it as the same date that you filed in the US or in your home country, but we're talking about the US here. So what that means is if you file on January 1st in the US and then wait until May 30th to file in a foreign country, they're going to treat it in that foreign country if you claim priority. And usually there is some extra fees and some extra work to claim priority because in many instances you need to get a certified copy over to that foreign government to see that. Madrid actually is another benefit of Madrid is that they streamline that process for you and make it easier. And I think ultimately cheaper. Again, why sometimes the initial filing with Madrid is better. So if someone, the whole grid thing about priority is that if someone then in that country files maybe after you filed your US, but before you filed in that country, they should reject that one based on yours, and you should have priority over them. So that priority date is really important. However, it doesn't mean that you can't file in that foreign country, unlike patents where there is like a bar date that if you don't take advantage of that priority claim, you lose it. Trademarks do not have that. You just run the risk that someone else might file before you. So where should we file international? When we're discussing with clients where, one of the main places we look is where is the client located? Usually they're in the US, that's why they're working with us to start, but sometimes they are foreign. So usually you want to think about protecting there. Then the next question is where are their current customers? Let's think about those countries where they're going to have their customers, where are they going to have their potential customers. And then another big one is manufacturing. Because so much manufacturing is done overseas, you should really consider protecting your brand there. And this list is not necessarily in any order. It's very case by case specific, but protecting where you manufacture is a good idea because they're going to have to export that. And if someone else files there, they could potentially block your goods that you had manufactured in that country from being exported and shipped to the US. And then another thing we also ask is, well, where do you think maybe a potential counterfeiter would be? Again, a lot of times that's going to be the same countries where they manufacture because they can manufacture and just ship it out to someone else under your name. So that's just a quick little rundown about international filing, some considerations there. Of course, if you have any questions, you can always reach out to us at 888-666-0062. Thanks for listening in. Have a great day.